Okay, this is Willoughby Estates 2 LLC versus Wyland Corporation et al., docket number 19-540CB. This is the time set for hearing on the defendant's motion for partial summary disposition. And could I have appearances for the record, please?
Good afternoon, Your Honor. Kevin Blair on behalf of Defendant Wheelan Corporation.
Good afternoon, Your Honor. Jeff Toyer on behalf of Plaintiff Willoughby 2.
All right, thank you. And Mr. Blair, this is your motion. Whenever you're ready, you can go ahead.
Thank you, Your Honor. We addressed the issues in the briefs, and I won't belabor those points too much. I just want to highlight a few things. There are two main issues in dispute here. The first is whether plaintiff can maintain count 2, which is a tort claim for negligent construction when the duty that was allegedly breached arose from the contract. The second question is whether the plaintiff can avoid the plain language of the contract, which includes a very broad waiver of all consequential damages. The first issue, as we noted in our reply brief, defendants cited several controlling cases that there is no tort claim when the duty that is allegedly breached comes from a contract. That's Ronaldo's, Hart, Freeman, and plaintiff didn't even attempt to distinguish any of those. In our opening brief on page 7, we outlined there that the allegations in count 1 and count 2 almost perfectly mirror each other, and it is plaintiffs, in plaintiff's own words, in their allegations, they allege that the mold resulted from the breach of a contractual duty. That's in paragraph 41 of the complaint. If the mold was the result of some breach of a duty, that duty must have been a contractual duty. The contractual duties are very broad. Section 1.1.3, the word work is broadly defined to include all construction and all services to fulfill contractors' obligations. In section 3.3.1, there's a duty to supervise and direct all work, capital W work, using best skill and attention. And section 3.5, all work, again, capital W, must be free from defects. That's just a sample of several contractual provisions that clearly cover the allegations at issue. Now, there are some red herrings in plaintiff's brief. There's several pages about plumbing tees that go on and on, even after footnote 1 admits that claim has been resolved. That claim is not at issue here. The parties mediated that issue and it's been resolved. On page 5, they say that that's helpful background, but again, it's completely irrelevant, and it's just there to put Wheelan in a bad light. It's a one-sided recitation of what happened anyway. The stud holes were, in reality, the stud holes were drilled per the architect's plans, and Wheelan spent a lot of time and money trying to fix the problem once some of these T-joints started to break, and that one-sided view of how Willoughby saw the plumbing issue. I mean, first of all, it's been settled, and second, it's not helpful background because it has nothing to do with the mold or the underdrains issue. It's really only there to distract from the straightforward legal issue of whether Willoughby can maintain a tort claim for an alleged breach of a contractual duty. Now, the response boldly asserts that there was some separate duty that aside from the contractual duty, but we cited case law in our reply brief. That's clearly not sufficient to survive a motion for summary disposition. And also in Ronaldo's, the Supreme Court clarified that it's not, a mere allegation of a separate duty isn't enough. The court must analyze the facts as they're pled and determine whether those support a claim for a breach of tort duty. Again, here, the contractual duties are very broad, cover everything that Wheelan was supposed to do, all services related to any of Wheelan's obligations, and plaintiff's own allegations are that the mold resulted from a breach of a contractual duty. In Ronaldo's, the court agreed that the defendant there had a duty to hire competent employees and to perform its work with reasonable care and due care. But the court found that just like in Hart, all of those duties stemmed from the party's contract. And so there was no viable claim for tort. This is not a case where there was, Wieland was negligently swinging a hammer and injured Willoughby's project manager. That's not this case. In the Fultz case, they distinguished another snow removal case where a plow, created a new hazard. And that's the kind of tort that might be an independent duty where, you had a contractual duty to plow a driveway, but if you created a new mound of snow that melted and created a new hazard, then you might have an independent tort duty to use reasonable care not to hurt people that might be walking by. The Van Islander case that was one of the unpublished cases that we cited in our reply brief, that case also distinguishes the Johnson case. In that case, there was a tow board that contractors were using to keep their footing as they were putting shingles on a roof. And one contractor allegedly put the tow board on negligently, and the tow board came off, and somebody slipped and fell. And the court said that normally the construction injury cases, it's up to the employee's direct employer to keep the job safe. But an exception to that exists if one contractor negligently performs work that then hurts another contractor. Again, that's not what happened here. All of the duties stem from the contract, and this wasn't swinging a hammer and hurt somebody. This was the contract required to perform the work in accordance with the contract documents, which included installing cabinets, and the cabinets were installed. And if those were defective in any way, then that breached a contractual duty, even according to plaintiff's own allegations. So the Baranowski case, I'll just address very quickly. That's a 1976 Court of Appeals case. That's a bit of a head scratcher. I would say there was, a contractual duty to build on suitable soil. There was no dispute that the soil wasn't suitable there. But somehow the court found that wasn't a breach of contract. It was a breach of some independent duty to test the soil. Now, no case has cited that case and adopted plaintiff's interpretation of that case in 43 years. I think it's more likely an anomaly and does not represent a valid exception to the general rule outlined in the several cases that we cited. And again, plaintiff didn't attempt to distinguish. But as we note in the reply brief, the court need not even reach that issue. This court need not decide whether Baranowski can be reconciled with all the other controlling cases, because according to plaintiff's own allegations, it was a breach of a contractual duty that resulted in the mold. Onto the consequential damages, again, this is a very straightforward legal issue. We're just asking the court to enforce the plain language of the party's contract. There's red herrings about the mold and again, kind of a one-sided telling of it, as if Wieland was some evil company that was trying to get away with installing moldy cabinets. One, it was not an infestation of mold throughout the project. This was a huge project, hundreds of units, and there was a handful of units on one floor in one building that had a mold issue. We also took Willoughby's deposition, and Willoughby's representative confirmed that Willoughby was happy and satisfied with what Wieland did at each step of the process. Wieland spent a lot of time and money trying to fix it, and Willoughby's representative agreed that it was a proportionate response. The first time they found the mold, nobody claims that Wieland should have ripped out all the cabinets right away. First time they were wiped down. Both sides inspected it. Willoughby did a walkthrough. There was no visible mold. Nobody had a problem with that. After the tenants moved in, mold appeared in some tenants' units, one of which had the tenant was actively humidifying the air in June, July, 90-degree temperatures with an active humidifier running. And then the third time they ripped out all the cabinets and replaced them. So again, the details of those is a red herring. It's separate from the legal issue of whether the court should enforce the plain language of the consequential damages waiver. We're not asking for a ruling that Whelan's response was adequate. The legal issue is whether the consequential damages have been waived. The section 15.1.6 clearly waives all consequential damages arising out of or relating to the contract. That's really broad language. In the context of arbitration, courts have said that's extremely broad, and it's not just when the contract is terminated. That is given as an example with the language without limitation. As I noted in the reply brief, I'm not aware of any case that has adopted the plaintiff's interpretation of this provision. It's a standard provision that is in the A1A contracts. And the only two cases I could find that address this issue, I'm not just cherry picking the good ones. The only two cases I found that address this issue squarely rejected plaintiff's interpretation, saying that interpretation is not supported by the plain language of the provision. The examples of what plaintiff is seeking here are exactly the same as the examples given in the contract for consequential damages that the parties explicitly agreed to waive. That's lost use, lost profit, and increased project management costs. We're not asking the court to drill down and specify a precise number of damages that are not allowed, or get into whether a mover might be a contractor and maybe that's consequential or maybe it's not. We're simply asking the court to confirm that the contract includes a waiver of consequential damages, and then we can flesh out the details of what that means for the precise dollar figures in motions in limine if necessary. But I think just confirming that the consequential damages waiver is valid and enforceable and doesn't only apply in cases of termination would be very helpful in breaking the logjam and potentially helping restart settlement negotiations. As the court might have seen from the amended affidavit that was filed last week from plaintiff, the lion's share of damages, alleged damages related to the mold, involve lost use, and that's a specific enumerated example of the types of consequential damages that the parties specifically agreed to waive. I'd be happy to answer any questions. Those were the points I wanted to make. I'd like to reserve a little bit of time for rebuttal if possible and answer any questions the court might have.
Yes, I'll give you rebuttal time. Mr. Toyer?
Thank you, Your Honor. Initially, I guess I'd like to note that the damages waiver only applies if count 2 is dismissed. Count 2 is the negligence count. And all of the case law cited by Whelan in this case is fully consistent with count 2 for negligence in this case. That's why we didn't discuss them, because there is nothing to distinguish in those cases. And I'll go through that in just a minute. Baranowski is not an exception to those rules. Baranowski is an application of those rules. The rule is well established, and it doesn't post-date Baranowski. It's been around for a long time. It goes back at least to Hart versus Ludwig, which is a 1956 case that itself cites 1700s and 1800s cases. And what it says is that misfeasance in the course of contract performance is a tort. Non-feasance is a breach of contract, and only a breach of contract. The language is pretty clear here at page 562 of the opinion, which is, quote, if a party undertakes to perform work, he makes himself liable for any misfeasance in the course of that work. But if he undertake and do not proceed on the work, no tort action will lie for non-feasance. That's the rule. In Hart, it was unreasonable delay in the performance of maintaining an orchard, which caused revenue damages, essentially. The court determined that delay was non-performance, and that is a theme throughout the case law, is that delay is non-performance. That's a breach of contract. You can't maintain a negligence action for it. And that's not the facts that we have in this case. Interestingly, and specifically, the court in Hart said at page 563 to 64 of the opinion, if the defendant had performed the work contemplated by its contract unskillfully and negligently, it would be liable to an action of tort. So we see here we've got this bifurcation here. If there is misfeasance in the performance of a contract, it is a tort. If it is non-feasance, that means it's only a breach of contract. And that's the way all these cases go. Ronaldo is a case that was in a heavily regulated industry, telephone services. And the court in that case, it's actually a primary jurisdiction case.
Oh, hold on. The recording system froze.
Okay.
Shut it down right quick.
She's got to reboot it real quick.
Just came in.
Remember where you were.
Yes, I remember.
I'll just ask you to back up about 10 seconds, maybe 15. Moving.
Okay, we're good.
Well, we are, except why did the Polycom shut off?
So be video conference.
Oh, here we go.
Okay.
Return to call. Sorry, this time I can't blame Zoom. It was a recording system. We're set. Go ahead. If you could just back up.
Yeah, let me just finish, where we, a little before we stopped. I want to reread that short quote from the Hart case because it's critical to understanding what the status of the law that applies here is. And that's at page 563 to 64 of the opinion. It said, quote, if the defendant had performed the work contemplated by its contract unskillfully and negligently, it would be liable to an action of tort, close quote. What that means is that there can be two bases for a cause of action. There can be a negligence claim, and there can be a breach of contract claim. Ronaldo's is not really different. It's not factually on point because it's really a primary jurisdiction case rather than a contract case, but it does rely on Hart and quotes it at length. In that case, it was alleged a negligent installation of a phone service. That's a heavily regulated industry. And the court determined that the obligation to install the phone service and do it correctly was all done under a tariff that should be overseen by the MPSC. So they dismissed the case to send it as a matter of primary jurisdiction to the MPSC. More on point would be the Freeman case that is again cited by the defendant, Freeman Darling versus Andrew Storin, 1986 Court of Appeals case. That again was a failure to perform, a non-feasance case. The contractor failed to designate a subcontractor. Work was delayed as a result of that failure to perform. In discussing Hart, the Freeman court said, the court went on to identify the important distinction as being one of misfeasance, which may support an action in either tort or contract, and non-feasance of a contractual obligation, which gives rise only to an action on the contract. In that case, there wasn't a tort because it was a delay case. And again, the courts view delay as being non-performance rather than misperformance. Fultz is also no different. It cites the exact same rule. It's a different set of facts. It's a slip and fall case. The plaintiff in that case was trying to get liability on a contract that it wasn't part of. So it was a third-party beneficiary. And again, the court stated at page 465, if a defendant voluntarily performs an act, a duty arises to perform non-negligently. Tort action for misfeasance may arise if it violates that duty, even under a contract. This is where we get to Baranowski. Baranowski is far from a head scratcher. It's the application of those very principles. What Baranowski says is that when a construction contract is at issue, there is a separate independent duty, and it's a duty of due care to construct the project with due care. And that's what we have here. Baranowski was an owner suing a contractor for failing to do soil boring tests, which would have supposedly, as alleged, would have resulted in a discovery of unsuitable soils, and the house wouldn't have sunk. The court found specifically, and interestingly, the court did not find that there was a breach of contract in that case, even though one had been alleged. The court only found that there was negligence, and the negligence was based on the fact that defendants owed a duty to the plaintiff to exercise due care in the construction of the house. That's the conclusion at page 556 of the opinion. So what we have here is we have a construction contract in this case where there was a due care obligation owed by Whelan to Willoughby that is independent of the contract. It can support either a breach of contract action or a tort for negligence, and that's what we have here. The fact that there was a contract makes no difference. It didn't matter in Baranowski. There was a contract in that case. It didn't matter in Freeman. In fact, in Freeman, they explained that. The court said, while the contractual relationship brought the parties together and furnished the occasion of the tort, the defendant owed a general duty imposed by common law. That's stating the rule, which applies to this case. And that's that there is both a tort and a breach of contract basis for the action in this case. Yes, there was a contract. Whelan, we allege, acted negligently in the performance of that contract, and it led to mold, it led to the broken T-joints that were settled, it led to a lot of other things. But the main point here is that there is an independent duty. That's Baranowski. It's good law. It's consistent with everything that's came before it, including the law that's been cited by the defendant in this case. So with respect, let's see. Yeah, the only thing I'd say with respect to Van Elzender, which was attached to the reply brief, is in that case, it was a subsequent purchaser that was asserting breach of contract action in that case and negligence. So what the court said is that there's no duty to a subsequent purchaser on a contract. The fact that they mentioned Baranowski is interesting because the court actually distinguished Baranowski based on the fact that there was a contract in Baranowski, and there wasn't in Van Elsender. The difference being that you can bring an action based on both, based on the contract or for the independent duty of due care and construction, which is recognized in Baranowski. So that's the negligence part of this. Negligence has its own set of damages, and those include consequential damages in addition to several other things. When we're talking about the waiver of damages clause here, which I'll move to now, that only has application if, in fact, the contract is the only claim that can be brought. But in this case, first of all, as we cite in the various, in the sort of lengthy cases that we cite in the brief, whether a particular damage is consequential or direct is a matter for the jury to decide in the first place. It's a fact matter that is appropriate for them. But even if the court wanted to get into it, the damages in this case are direct. And I would point the court to the affidavits in Exhibit C and D to our brief, in which we discuss how these damages were incurred. Yes, there's lost rent involved, but it's not the kind of rent. And again, this is a factual issue. The consequential damages can be different under different sets of facts. And in this case, the lost rent is directly applicable to the performance of the contract. So in other words, what had to be done here is things had to be removed. There had to be treatment with harsh chemicals. And in order to do all of that, you had to move the tenants out. So in order to give the plaintiffs in this case, Willoughby, the benefit of their bargain, which is the standard breach of contract damage, you had to get the tenants out. And in order to get the tenants out, you had to push them somewhere. You had to relocate them. And that's what we did. Willoughby moved them to other apartments within the unit and incurred damages so that it could get the benefit of its bargain under the contract. And that is a usable building L that didn't have mold. So these are direct and case specific. That's the Dierix case cited in the brief. So let's see. And then with respect to the applicability of the damages waiver to termination, the language says what it says. It says it applies without limitation to termination of the contract. There's very little case law in this. The only cases cited by the defendant are two unpublished cases. One doesn't involve the AIA document. It's a Walmart case using their own version of a construction contract. The other case is an AIA contract, and it says it has the same language here. It's one court in an unpublished opinion making one decision. We would argue that the language there would serve indicating that it applies to terminations wouldn't have any meaning unless it was intended to be when the contract provision applied, and that's only when it's terminated. And here, nobody terminated the contract. We all agree on that. And then finally, with respect to the damages themselves, as we cite in the brief, and I won't go through them in detail, but there are numerous sections of the contract that specifically provide for specific types of damages. And those include the types of damages that are being sought in this case, and that's the section 6.2.3 damages, the 6.2.4, 12.2.1. These are all cited and described in the brief, so I won't go over them. But these all require a contractor to remedy damage, to provide testing if there are problems, to repair rejected work. And in order to repair the rejected work, in order to repair the damage that was caused to this property, in order to return the owner to the position they would have been absent the breach, the only way to do that was to relocate these tenants, get them out so that the cabinets could be removed, so that chemicals could be brought in, so that testing could be done on a periodic basis to ensure that there was no mold left. So all of this means that not just the waiver. The waiver has to be read with the rest of the contract, and it allows a much more broad availability of damages, which includes the damages in this case. And again, this is for the jury to decide in the first place. And if the court has any questions, I'm happy to answer them.
I don't have any. I'll give Mr. Blair some rebuttal time.
Thank you, Your Honor. You're on mute, Kevin.
You know, no matter how many times you catch other people doing that, once a week I do it myself. I'm sorry about that. I wanted to start with the quote from Hart. Brother Counsel read some of that. The sentence that he read, if the defendant had performed the work, quote, if the defendant had performed the work contemplated by its contract unskillfully and negligently, it would be liable to an action of tort, because in such case there would be a misfeasance, which is a sufficient foundation for an action of tort. So again, that's from a 1956 case and talking about the misfeasance. And Brother Counsel, spent a lot of time talking about the misfeasance and glossed over that the Supreme Court rejected the slippery distinction between misfeasance and non-feasance in the Fultz case in 2004, saying that it really just obscures the real inquiry is whether there's a duty owed. And again, back to the duty, all of the duties owed regarding the cabinets necessarily emanate from the contract. The contract has very broad contractual provisions covering all work related to fulfilling contractors' obligations. Plaintiff itself has alleged that the mold resulted from the breach of a contractual duty. The comments about Baranowski and how that, it's not a head scratcher and it's just a simple application of the law. If that were true, surely that there would be several cases citing it for that proposition, but there have been 0 cases citing it for that proposition in 43 years. That case was issued over 43 years ago, and no court has adopted plaintiff's interpretation of that case. It's not an exception to the general rule. It can't be reconciled with the general rule. It has been distinguished, and the Van Eisler case, it was distinguished for 2 reasons. 1, it predated Fultz, and 2, because there was a direct contractual relationship. But in the Freeman case, footnote 1 explains that even though that case involved a third party to the contract, said that the analysis was exactly the same as in Hart because the duty emanated from the contract. Again, back to our case, there's no duty to install cabinets without the contract. That's the contractual duty. This wasn't swinging a hammer and hit somebody by accident. If the cabinets were defective, then that breached the contractual duty, and plaintiff itself has made that allegation. Whether the jury should decide whether this is onto the consequential waiver, consequential damages waiver, plaintiff argues that this is a jury issue. There's not a single Michigan case to support that in plaintiff's brief, and we're not asking for the court to extrapolate and again dig down into all the different categories of damages. We're simply asking to confirm that the waiver of consequential damages means what it says, and some of the claim damages are exactly specified as examples in the contract. The other provisions in the contract, again, those don't change the waiver of consequential damages. That waiver couldn't be clear. The plain language, the parties agreed to waive consequential damages. Plaintiff cannot avoid that by saying it's just the benefit of the bargain. In Perini, the casino could have said the millions of dollars of damages was just the benefit of the bargain because of the facade took longer than expected. The duties emanated from the contract, and the parties agreed to waive consequential damages. We can flesh out the details of what that means in terms of dollar figures as we get closer to trial if necessary. But again, the lion's share of the consequential damages relate to this lost use, which is specifically enumerated in the contract as an example of consequential damages that were waived. So if the court doesn't have any other questions, defendant just asks that the court grant partial summary disposition dismissing count 2 because there's no duty alleged beyond the contract, and confirming that the waiver of consequential damages applies as well.
All right, thank you. I will start with count 2, the negligence claim that the defendant is asking the court to dismiss. Tort liability is dependent on, of course, a duty that's owed, and where there's a contract between the parties, as there is here, there has to be a breach of a duty that's distinct from a breach of the contract. So, stated another way, there is no tort where the allegations are based solely on non-performance of a contractual duty. The plaintiff's argument, and this relates solely to the mold, the plaintiff says that the duty to construct a project free of mold is independent of the contract, and it's based on industry standards. I don't find the 1976 Baranowski, Baranowski case as dispositive or even helpful, because it came long before Fultz, F-U-L-T-Z. And of course, since the Baranowski case, we've had a merciful reprieve from the whole misfeasance, nonfeasance mess that we were all struggling with. And we no longer analyze it by that standard. Rather, it's just a simple analysis of is there a duty that's separate from the contractual duties? What is dispositive in this case, I think, is an examination of the complaint. So the complaint is alleging that during the construction of Building L, cabinets were stored on a moist concrete slab with no moisture protection, and that caused moisture and mold issues with the cabinets and the trim, and those damp and damaged cabinets were used anyway in the construction of Building L, and that resulted in mold growth. While it's true that the contract never uses the word mold or says, you will not construct this building or this apartment complex rather with mold in it, the mold claim really is based on negligent performance of the contract and not any duty distinct from the contract. This is what the contract is, what the complaint is alleging, is that the cabinet work, which was most definitely a duty under the contract of the work that was to be performed in constructing these apartments, the cabinet work resulted in mold and mold damages. That emanates directly from a duty that is in the contract and part of the contractual duties. So I believe that the defendant has correctly requested dismissal of the negligence count as there is no duty that's distinct from the contract, and what's really being alleged here is non-performance of a contractual duty. That takes us to the consequential damages and section 15.1.6 of the contract. The plaintiff says that this section only applies when there's been a termination of the contract and neither party terminated the contract here. The Walmart stores case provides, it's of course not binding, but it provides, I think, persuasive guidance in interpreting the same standard provision in a contract, and I adopt that reasoning. I'm modifying it a little bit to make sense, but it's basically as follows. It says, the provision is best read as providing a broad waiver for future claims for consequential damages arising out of or related to the party's construction contract. The termination in accordance with provision is most consistent with the provision as a whole when it is interpreted as an example of when the waiver applies, as opposed to identifying when the waiver does not apply. This comports with the provision's general approach of expressing the general waiver of claims for consequential damages, then providing non-exclusive examples of the damages and situations to which the waiver applies. This interpretation harmonizes each of the provisions and in the section and unambiguously establishes the party's intent to avoid claims for lost profits in the event of a breach. And I am interpreting the section 15.1.6 exactly the same way. It involves a broad, expansive waiver of consequential damages, and then as an example says that it also applies to consequential damages due to either party's termination. And of course, neither party terminated in this case. So, but the section, as I read it, and as the Walmart Stores Court analyzed it, does apply, even when there's been no termination by either party. Nevertheless, the entire contract must be read as a whole. And I think the plaintiff correctly points out that its damages claims could well fall under other provisions. We have section 6.2.3, costs payable to a separate contractor because of defective construction. We have section 6.2.4, remedy for damage. We have section 12.2.1, costs of correcting rejected work. We have section 12.2.4, cost of correcting destroyed or damaged construction. And we have section 3.18.1, indemnification for losses attributable to sickness or disease, all of which are potential sections that are part of the contract and apply potentially to the various components of damage that the plaintiff is claiming. And I furthermore agree with plaintiff that at least in this scenario, whether the very specific elements of damage fall under any of these provisions, some of them certainly potentially do, or whether they fall under the other section that waives consequential damages is a question of fact. It's really dependent on what, if any, breach occurred. And I do think in this particular scenario, it is a question of fact as to which provision of the contract those damages could potentially fall under. I'm sorry that I can't narrow it further for you, as was suggested, to further settlement of this case, but I think that in order to do that, I would have to make findings of fact, which of course I cannot do. But I am ruling that while the waiver of consequential damages clause does apply, there are other clauses that apply as well that can cover some of the damages, if not all of the damages, depending on what facts are determined to be true, the plaintiff is claiming. So for those reasons, I am granting the defendant's motion for partial summary disposition as to count 2, the negligence claim, and I'm denying the defendant's motion for partial summary disposition as to the consequential damages, or the damages claims. And one of you can do an order that reflects that for the reasons stated on the record.
Yes, Your Honor. Thank you.
Good, Your Honor. Thank you.
Okay, thank you. That'll conclude our hearing.
Thanks.